My name is Annalisa Goodman, and I'm on the communication team at Drexel University Klein School of Law. Today, I am joined by Klein student Sarah Fishel to discuss Hamilton and the law, reading today's most contentious legal issues through the hit musical, which was edited by Klein Professor of Law Lisa Tucker. Sarah, thank you so much for joining me.
No problem. Thank you so much for asking me to be here.
Well, it's my pleasure. I'm really excited to talk to you. So tell me a little bit more about how you became involved in Hamilton and the law.
Absolutely. So I was in Professor Tucker's legal methods class my 1L year. And as a part of that class, we write a brief. And throughout the semester, we do these student check-ins, partially to discuss the brief, but also just to get to know us better. So our discussion turned to my master's thesis, which focused a lot on anticipated early death and these types of themes that I discuss in my chapter. So during that meeting, we were talking about my thesis and we were talking about Hamilton, which everyone was talking about. And at one point, Professor Tucker asked me if I saw any connections between the two, but Hamilton and anticipated early death. And I immediately thought of and said two different lines. One was, I never thought I'd live past 20, which ended up being part of the title. And then the other one, I imagine death so much it feels more like a memory. She asked me then to read over the book proposal that she had written. She had already had all the authors joined on. And so, she asked me to write a proposal for what my chapter would look like. And I did it and submitted it, and she accepted it. And I was able to jump in on this amazing opportunity as a 1L.
So let's get into your analysis of it. You explore Hamilton's belief that he will die young to frame some of the risky decisions and behaviors he engages in as a young adult. Mm-hmm. You draw comparisons with subpopulations in today's youth who are more likely to think they will die young. Can you tell us a little bit more about what these subpopulations are like today?
On the surface, anticipated early death stands for the proposition that some individuals may not live or expect to live a full lifespan. But there's a little bit more going on underneath the surface with the theory. It's that some individuals engage in risky behaviors, sometimes criminal behaviors, like positioning yourself at the nexus of a revolution when you're 18 years old, because they believe they will die or be killed prematurely. And so current research from different scholars, some of whom call what they're looking at anticipated early death, some call it different things like future discounting or perceived survival expectations, look to, in a lot of ways, early childhood. Carlock has said that early exposure to unpredictability and chaos in one's life can lead to this. There's also been a lot of research on direct and indirect exposure to violence, whether that's victimization, childhood abuse, witnessing or engaging in serious violence. And then there's also gang membership, adherence to street culture. A lot of authors have spoken about street culture being in a lot of ways like a war zone. Which I, again, find a lot of connections to Hamilton in that way. And the list goes on, but really it's those early chaotic and violent experiences that can lead an individual to think that, in some ways, it makes a lot of sense that an individual would think that their life may not be as long as, the traditional lifespan, in some ways because they see other people, their peers, their friends, people from their community die young, and so their expectations are also reduced.
So how do their beliefs contribute to increase the likelihood of engaging in risky or illegal behavior?
So in the chapter, I make the analogy to the bucket list. And we think about that as all these things I want to accomplish before I, kick the bucket, right? Before my life ends. And I think there was a movie with Morgan Freeman a couple years ago, and it's, he goes out and does all these things like skydiving and, everything that, we think of might be on a bucket list. So those are riskier behaviors that when you aren't thinking so much about protecting yourself, you're more willing to engage in. And, some might go skydiving and some might be more willing to engage in other forms of risky behavior, getting themselves into violent situations, or, just changing the way that they value different things. For example, valuing respect or territory in one's neighborhood over, thinking about what is my next step? Am I going to go to college? Am I going to start my family? All of those different things. So if someone doesn't believe that they have command over their future, or cannot think that they're living to see the consequences of their actions, or they think they're going to die young regardless of what they do, they're more likely to take unnecessary risks than someone who believes the opposite. And we're not quite sure in the social sciences fields why this happens. There are different theories of crime and behavior, like social control theory, that's people don't have an incentive to delay that gratification if there's no future to hold on to, or rational choice, which is a different theory that focuses a little bit more on making the decision to discount the future and any long-term consequences coming from those risky behaviors.
It seems like that mindset it really influences the individual's behavior, but that mindset negatively impacts the communal experience, right? If we have these individuals who are engaging in risky behavior, especially if it's illegal, which is really interesting to consider in the context of Hamilton. He joined a movement that benefited the community ultimately, but that's not necessarily what we see today.
This isn't always something that's negative. And like you said, in Hamilton, he had this, he was incredibly risky. He did all of these risky actions, was in the middle of everything. And his friends kind of pumped him up in that. They all got together and talked about this and were ready to go. And that can happen in any community, from, going out and partying when you're young, or it can look like, street racing. It can look like all sorts of different things, including illegal activities that, might turn out to have more negative consequences for the youth of today than for Hamilton.
You say that the juvenile justice system has remained structurally distinct from the adult justice system because policymakers acknowledge that you think differently about consequences to their actions. How do you evaluate this system of juvenile justice policy? Is the way in which our legal system distinguishes between juvenile and adult defendants sufficient?
Mm-hmm. The best way to demonstrate how the legal system acknowledges the differences between youth and adults is when we look to the Supreme Court's jurisprudence on juvenile death penalty cases and its progeny, now moving into life without parole. And I actually have an article coming out in the Drexel Law Review that delves a little bit deeper into this, so I'm going to pull a little bit from there. You look at, especially beginning with the case Roper v. Simmons, which relied heavily on neuropsychology and psychology to establish the difference in thinking and behavior between juveniles and adults, in which, Supreme Court expanded previous rulings and named the death penalty for juvenile defendants under the age of 18 unconstitutional, citing specifically that lack of maturity, undeveloped sense of responsibility, vulnerability and susceptibility to peer pressure, like we were just talking about, getting in those groups, and just the malleability of personality. So going to your second point, which is it sufficient? The short answer is, in my humble opinion, no. On a human level, as someone who studies psychology, I find it hard to believe that the malleability of the human spirit or the human psyche, or whichever you want to call it, just disappears when people turn 18. That would totally upend pretty much everything that we do, from higher education to therapy itself to self-help books, it's all predicated on the fact that we change as individuals. So from a neuroscience perspective, we know that the brain continues to develop beyond the 18th birthday, way beyond the 18th birthday. And further, our neural connections are continuously shifting and changing. So there's some support for my, short quippy answer of no in the legal system. Actually, Justice O'Connor, in her dissent in Roper v. Simmons, also argued against a bright line rule that, cut off people at the age of 18. Truthfully, between 17-year-old 364-day old defendants and 18-year-old defendants. However, she argues kind of for the opposite, that people under 17 could be mature enough to qualify for the death penalty. Whereas I'm arguing the opposite, is that, we should be able to expand this understanding of the mind and understanding of behavior to meet all of those defendants and everyone's needs, and have less of a bright line rule that, when the clock turns midnight on your 18th birthday, all of a sudden you don't qualify for any of this.
Given the persistent presence of this mindset in certain young populations, is there any law, policy, or cultural shift that you see that could help change mindsets and potentially decrease criminal activity and improve health and well-being amongst these young people?
This change in mindset happens in a lot of ways because individuals all of a sudden realize that they're growing up. They haven't died yet. So it's that kind of cognitive dissonance that occurs when one's expectations are not met. And that can also happen, and you see it a little bit with Hamilton, and I speak about it in the chapter, when he himself becomes a father and gets married. And all of a sudden, he's thinking about the future rather than the now and what's going to happen with me. And if I die today, here's what my legacy is. I want to go out and battle. And all of a sudden, he's saying, let's not shoot, let's be cautious, let's go into this quietly, and eventually wins the revolution in that way. So there's some things we can do to change these mindsets on an individual basis and on more broadly, beyond just waiting for people to age out. More broad level, on a systemic level, we can consider the presence of anticipated early death during the sentencing process. And I want to be clear here. So anticipated early death is no excuse for committing serious crimes. And I'm not advocating that those who anticipate an early death should be allowed to act in any way with impunity until they age out and no longer anticipate an early death. But I think that judges could consider the presence of this mindset as a mitigating factor in sentencing, partially due to the importance of assessing risk in crafting an appropriate sentence. Because anticipated early death is so closely associated to age and so closely associated to risk, it would make sense that that's something that we could easily target for reducing recidivism. Courts are beginning to think in these ways. For example, federal courts use the PCRA as a risk assessment measure, which does incorporate what we call criminal thinking styles, which I would argue anticipated early death could fall into. We're seeing courts starting to apply these more kind of psycho-legal approaches to sentencing and to understanding defendants, especially with the rise of therapeutic jurisprudence and understanding that the context in which one enters the system impacts their whole reality and their, rehabilitation through the system, if that's really what we're going for as a community, as a nation, is rehabilitating people. And that's important because these analyses not only determine sentencing, what people are allowed to do when they're inside. For example, death row defendants aren't given, in a lot of cases, the same resources that people who are in the general population, or people who are on mental health units, or people in the juvenile system. And that can, in turn, reduce or increase risks of recidivism and also collateral consequences for when they are released back into the community. So this shouldn't be, again, going back to your last question, in my view, this shouldn't be limited to individuals under the age of 18. In the words of the Eddings Court, youth is more than a chronological fact. It's a time and condition in life when a person may be more susceptible to the influence and psychological damage. So if you think of youth as more than a chronological fact, all of this should be considered on a broad systemic level to change policy and the way we're sentencing people in order to come to a greater understanding of their behavior. And I think also at the underscoring all of this, we need to remember that anticipated early death, it develops from trauma. So using trauma-informed treatments to address the root pain, the root cause, can also help our youth heal. And exactly what you were saying earlier, it's individuals, but it's also individuals within a community, within a system. And so you can work on the broad level down, and you can also work on an individual level out.
That was Sarah Fishel on her chapter, I Never Thought I'd Live Past 20, Hamilton Through the Lens of Anticipated Early Death. You can read her whole piece in Hamilton and the Law, reading today's most contentious legal issues through the hit musical. which can be ordered online at hamiltonandthelawbook.com.